Al Jazeera. You spent 6 months reading every provision of the Amparo reform before it went into effect, and what you understood at the end of 6 months is that the reform narrows the tool without eliminating it. The suspension mechanism is more constrained. The window for filing is tighter. The evidentiary threshold for obtaining a suspension has been raised. The reforms were designed specifically to address the pattern that your practice has been part of: the systematic use of constitutional mechanisms to delay extraditions of organized crime defendants. The reform represents a significant setback in safeguarding the country's human rights and further erodes trust in the judiciary. Vision of humanity. The human rights organizations say this. You agree with them, and not for strategic reasons. The restriction of the Amparo's scope damages the instrument that protects everyone: the wrongfully imprisoned Indigenous woman, the political dissident, the journalist fighting a prior restraint order, and yes, your client, who is a plaza commander facing 40 years in Alexandria. The instrument doesn't distinguish between those categories of user. Making the instrument less effective for one categories makes it less effective for all categories. You made this argument in a law review article in October 2025. The article generated attention in the legal academic community, an uncomfortable attention from a different direction that manifested as a specific conversation with a person you had met 3 times before who expressed the organization's appreciation for your continued work and their hope that the work would continue. The conversation was brief and professionally conducted and communicated what it communicated without containing anything that could be recorded and used as evidence of anything. You went home that evening and ate dinner with your wife, and you said the day was long, and she said she knew and passed you something, and the evening proceeded. Lawyers of transferred cartel members said they had no legal recourse within Mexico to challenge the transfers once their clients were outside the country. Northeastern Global News. The August 2025 transfers are the moment the practice confronts its structural limit. 26 clients transferred not through the extradition treaty, which you can work with, which you can challenge, which produces the Amparo opportunities that your practice is built on, but through the government's national security powers, which bypass the treaty, which bypass the judicial review that the treaty requires, which place your client on an airplane to Dulles International before the suspension motion you've drafted has been filed, let alone adjudged. One partner of a regional cartel leader went as far as to file a criminal complaint against Mexico's security minister, accusing him of treason. Northeastern Global News, you watched this complaint being filed, and you understood it as the specific legal gesture of someone who has run out of legal instruments and is producing documentation of the absence of remedy rather than pursuing a remedy that exists. The complaint is not going anywhere. The security minister is not going to be prosecuted for treason. The client is in American federal custody, and the complaint is a statement about the rule of law's current condition, rather than a mechanism for affecting it. 2 of your clients were in the August transfer. The transfer happened on a Tuesday. You found out on a Wednesday from a family member who had not been notified through official channels. By Wednesday, your clients had been processed into the American federal system, and your Amparo motions, prepared, complete, arguable, were documents that described a legal situation that no longer existed in the jurisdiction where the documents could be filed. You sat with this for a long time, not with grief, with the specific professional assessment of a person who has encountered the limit of his instrument. The instrument is the Amparo. The Amparo requires a proceeding. The proceeding requires a subject in jurisdiction. The subject is now in Alexandria, Virginia, and the jurisdiction is the Eastern District of Virginia, and the Eastern District of Virginia does not accept Amparos from Mexico City. The instrument has been outflanked, not defeated in the sense of having been legally overcome. The legal arguments remain as sound as they were on Monday. The government bypassed the legal arguments through the specific executive power that exists when political will is sufficient and American tariff pressure is sufficient, and the legal architecture is redesigned to reduce the judicial discretion that previously provided the entry. Points you worked with. This is the condition of the practice now. You adapt. 17 years of this work produces a specific adaptability, not to outcomes, to instruments. When one instrument closes, you find the next one. The Inter-American Commission on Human Rights still has jurisdiction to hear cases involving the rights of transferred individuals. The Inter-American Court has produced binding jurisprudence on the rights of individuals in extradition proceedings that the Mexican state is technically obligated to comply with. The American federal system itself has specific constitutional requirements around how evidence assembled through foreign intelligence operations can be used in domestic prosecutions, and those requirements create the entry points in the American courtroom that the amparo provided in the Mexican one. You have begun developing relationships with American defense attorneys in the jurisdictions where your former clients are now being prosecuted. Not because you can practice in those jurisdictions, you cannot. Because the legal theory you developed in 17 years of Mexican constitutional practice translates into specific challenges to the American prosecution's evidence base that American defense attorneys can deploy in American courts if they understand what the theory is. You are becoming a consultant. This is not the career you planned. It is the career the circumstances are producing, and you are producing it deliberately because the alternative is a practice that the government has outflanked and that you are unwilling to treat as finished. Your wife asks on a Sunday whether you've thought about leaving the practice. She is a person who has been married to this for 17 years and who has watched the practice grow from the small office on Reforma to the Polanco address, and who has managed the household through the fee structure's fluctuations, and who has never asked you to be a different kind of lawyer, and who is asking this question now with the specific quality of concern that constitutes her form of saying that she has thought about it, even if you haven't. You tell her you've thought about it. She says, and you think about the 43 filings. You think about the instrument designed by Mariano Otero in 1847. You think about the 2 clients on the airplane to Dulles and the suspension motions that described a legal situation that no longer existed. You think about the Inter-American Commission and the American defense attorneys and the evidentiary challenges that translate across jurisdictions if someone understands the theory. You tell her, the instrument still exists. The jurisdiction moved, but the instrument still exists. She looks at you for a moment with the expression she has worn for 17 years in the presence of this specific combination of your professional certainty and her reasonable concern. She says, okay. She passes you something. The evening proceeds. The amparo has exacerbated Mexico's impunity gap, in which the perpetrators of serious crimes walk free, while regular people can only access the amparo in theory. Only those who have money to pay for specialized lawyers actually benefit from it. Al Jazeera. This is the critique. You have read it. You have given it the full weight it deserves. The instrument that protects everyone protects most effectively the people who can afford the protection. This is not a feature of the amparo. It is a feature of every legal instrument in every legal system that has ever existed. The quality of representation scales with the resources available to purchase it. You did not design this feature. You operate within it with the skill that 17 years has built. The critique is correct. The critique is also not an argument for you to stop doing the work. It is an argument for making the instrument more accessible to the people for whom it is currently theoretical. These are different arguments, and you have given money to 2 legal aid organizations that make the second argument operational. Because writing a check to an organization that represents wrongfully imprisoned Indigenous women is not the same as not keeping cartel members out of American federal prisons, and you are not confused about the difference. You are a constitutional lawyer. You became, through the specific sequence of referrals and demonstrated results that 17 years in this specific city at this specific moment in this specific legal landscape produced, the person who uses constitutional instruments on behalf of people whose activities produce the outcomes that the American prosecutors are trying to prosecute. Both things are true. You hold them both. The holding is the work. The filing for the next client is due Thursday. Mexico used more draconian national security powers to bypass the amparo in order to overcome its abuse in cartel cases. Al Jazeera. The government is using national security powers more frequently now. The window is narrowing. The window is not closed. You file Thursday. You find the procedural defect in the American evidentiary provenance. You request the suspension. You buy time. Time is the product. You are still producing it. Drop your biggest takeaway in the comments. Mexico's amparo reforms and the government's use of national security powers to bypass the treaty extradition process is the most significant restructuring of the legal landscape for organized crime defendants in a generation, and we're covering every development. Subscribe. You don't want to miss what comes next.